the highest court in the state of New York just sent a powerful message to Donald Trump and Donald Trump's legal team. Go away. The highest court in New York just dismissed Donald Trump's appeal over the gag order imposed on him in the Manhattan criminal case where Trump was charged and convicted on 34 separate felony counts of falsification of business records. Donald Trump lost the issue over the gag order, which was imposed on him by Justice Merchan. He lost that issue where he tried to challenge it at the trial court. He lost that issue at the intermediate court level, the appellate division, and he just lost it right now as the highest court in New York, which is called the Court of Appeals, just dismissed Donald Trump's appeal on the gag order being imposed on him. Now, the gag order was limited in nature. It prevented extrajudicial, meaning outside of the court, extrajudicial statements attacking or going after the jury, statements attacking witnesses, and statements attacking the staff of the district attorney's office and their family members, including the judge's daughter, who Donald Trump continuously was attacking during the criminal trial before there was a slight modification made to the gag order. Let's take a look at the ruling by New York's highest court. Again, in New York, the highest court is not called the Supreme Court. New York likes to be a little confusing with it. The Supreme Court is actually their lower court in New York. That's their trial court. Then you have the appellate division, and what would normally be viewed as the Supreme Court or the highest court in New York is called the Court of Appeals. This was the Court of Appeals docket. Here was the ruling. Appeal dismissed without costs by the court sua sponte upon the ground that no substantial constitutional question is directly involved. Chief Judge Wilson and Judge Halligan took no part. So to be clear, what the highest court in New York is saying is that this doesn't even rise to the level of something that we need to address. There's no serious or significant or substantial constitutional issue here at all. That this is a normal process and procedure, and you're no different than the other criminal defendants who work their way through the court system in New York. You're now a convicted felon, and you're no different than the other convicted felons who are in the New York penal system. That is who you are, and there is no major constitutional issue. The First Amendment does not afford you, Donald Trump, the right, like it doesn't afford any criminal defendant or convicted felon, the right to attack juries, to attack judges' family members, to attack the district attorney's staff, to attack witnesses. That is not allowed, period, full stop. Now, this sends a powerful message at a very pivotal time, because you will recall that Donald Trump's lawyers recently attacked the gag order, and they went to Justice Merchan, the trial court judge who presided over the case where Trump was convicted on those 34 separate felony counts. And they said, hey, judge, we need you to lift the gag order now that the criminal trial is completed, that the same reasons why there was this gag order, which Trump's lawyer says was not constitutional in the first place, those same justifications don't apply, so lift the gag order, Justice Merchan. But now, especially with the highest court in New York affirming the use of this gag order, as every court in this country has done where there's been a gag order imposed on Donald Trump. It sends, I think, another message to Justice Merchan that there's no need to lift this gag order. The same basic concepts of protecting the integrity of your court still applies, even though there is no longer the trial taking place. There's sentencing taking place on July 11th. Donald Trump's going to do anything he can to still try to create issues to try to appeal on. So Trump's going to try to attack witnesses and attack the jury and say things to try to cause problems. The jury has been well protected, and if that gag order is lifted, the first thing Trump and his team are going to do is dox those jurors, and they've already have people doing that on some message boards, but that's one of the first things that they're going to try to do. So I think this also sends a powerful message to the trial court judge, Justice Merchan, that you don't need to lift this, The highest court in New York's got your back, the same way courts across the country have when dealing with the issue of gag orders imposed on Donald Trump. Now, you'll recall about 15 days ago or so, Donald Trump's lawyer, Todd Blanche, sent the following letter to Justice Merchan the day after the district attorneys issued a powerful response to it. Here's what Donald Trump's lawyer said, just to remind you, and this was to the trial court judge. This was before New York's highest court, the Court of Appeals, issued the ruling on June 18th. But Trump's lawyer says the following: Dear Justice Merchan, we respectfully submit this pre-motion letter requesting that Your Honor terminate the gag order restricting Trump's extrajudicial statements for the reasons set forth below. Because the trial has concluded, the stated basis for the gag order no longer exists, they argue. They said the proffered justification for the gag order, which we disagree with, pause there. It's great, Todd Blanche, that you disagree with it. The same way the jury in the case disagreed with you and convicted Donald Trump on 34 separate felony counts. The same way New York's highest court, which would be their equivalent of like what you would view as a Supreme Court, the Court of Appeals, disagrees with you. The highest court in New York says these aren't even consequential constitutional questions. Go away. Get out of here is what the highest court in New York is saying. It goes on to say, the proffered justification for the gag order, which we disagree with, related to the trial. And it says the government's February motion stated that the prosecution was seeking to protect the integrity of the criminal proceeding and avoid the prejudice of the jury. Then it goes on to say significant and imminent harm to the trial was also the justification for the gag order. And then it goes on to say, now that trial is concluded, the concerns articulated by the government and the court do not justify continued restrictions on the First Amendment rights of, they call him President Trump, even though he's not the president. And then it goes on to say, here are the reasons. Biden's May 28th campaign event outside the courthouse during the defense summation, Biden's public comments regarding the jury's verdict, continued public attacks against Trump by government witnesses Michael Cohen and Stormy Daniels, and the presidential debate scheduled for June 27th, 2024. I've always predicted that Trump's going to try to use the gag order as a way to avoid the debate on June 27th. That's coming up next week. Could you believe how soon? That's right around the corner, the debate. But Donald Trump's not prevented from going after Biden, going after the judge, going after Alvin Bragg. You just can't attack the jury, you can't attack witnesses, and you can't attack staff members of the district attorneys or their family. Then there was the response on June 4th by the district attorney's office that said, look, the same issues apply with the integrity of the proceeding. That's the justification for the gag order. Sure, there's no trial, but we need to protect the integrity of this proceeding. So the district attorney's office says, look, pursuant to the court's March 8th, 2024 order on the filing of future motions, the people submit the following. The people oppose any immediate termination of the orders. We'll do a proposed briefing schedule. Defendant's letter, Trump's letter, asserts that the stated basis for the court's order no longer exists because trial has concluded. The court's order, however, were based not only on the need to avoid threats to the fairness of the trial itself, but also on the court's broader obligation to prevent actual harm to the integrity of the proceedings, to protect the orderly administration of justice, and to avoid the risks of administration of justice. As the people will explain more fully in our written opposition to defendant's forthcoming motion, those interests have not abated. And then they say, in fact, like Trump's conduct is getting worse. And there's going to be a sentencing coming up on July 11th. So that all happened in the first week of June, right? And now, June 18th, you have New York's highest court also saying this gag order is fine. Not only is the gag order fine, it doesn't even raise any issues that are of a significance where we should even hear this. We don't even want to hear the motions. We don't want to even hear the briefing. Trump and your lawyers, just go away. These aren't substantial constitutional questions. This is a normal type of gag order. So Trump lost at the trial court, lost at the appellate division, now lost at the New York's highest court. Loser, loser, loser. And the gag order, of course, still remains in effect. And Justice Merchan hasn't ruled. He's not in a rush. Why would Justice Merchan be in a rush to rule for a convicted felon who behaved the way he did in that courtroom? Sentencing July 11th. We'll keep you posted every step of the way. I'm Ben Meiselas. This is the MeidasTouch Network. Have a wonderful day.
Enough! Send him to the big house, not the White House. Get the new exclusive tees, mugs, and stickers right now at store.meidastouch.com. That's store.meidastouch.com.